Do you need to update your estate planning documents if your beneficiaries have changed their name? I get asked this question a lot, that if you write your documents in your will and you have 3 children, one of them gets married and changes their name and to their new spouse's name, that does it require an update? Generally speaking, no, it doesn't, because there's a legal paper trail. The day that you signed your will, that was your child's legal name. And then there's a marriage certificate stating that they changed their name from the name you had written down to a new name. So the document itself still has legal authority, and it is perfectly clear that the name you have written in your will is the person who has a new name. It doesn't necessarily require a name change. However, if you're wanting for clarity's sake, a change like that would not be legally required, because we can identify who you intend when you wrote in your documents. But if you're wanting to make sure that it's perfectly clear that they're one and the same person, it's not a bad amendment. I would just say that it's not legally necessary. So while it wouldn't necessarily be legally required, it is worth mentioning on a review meeting with an attorney that if you're going back and reviewing your documents with your attorney, you can mention that they did change their name. If you are drafting an amendment or restatement, we can incorporate that new name just to make sure it's perfectly clear and there are no questions about it. However, if you're anticipating disputes, if there is going to be confusion, if you're worried that your beneficiaries, the people you have listed, are going to be arguing, and you want to get ahead of any sort of argument that anyone could make about your documents or their enforceability, it's probably not a bad idea to update that just to make it perfectly clear your exact intentions.